Hello, my name is Marlene Eskin Moses. I have had the honor of serving as president of the American Academy of Matrimonial Lawyers. I am a family law attorney from Nashville, Tennessee. The video you are about to view was produced by our organization's Committee on Public Service and Education and is designed to give you a general overview of the divorce process and some basic information about issues related to domestic violence. It is not meant as a substitute to consulting with and hiring a qualified lawyer who is experienced in matrimonial law. Marital property laws, support provisions, and laws related to children vary greatly from state to state and sometimes within a state. Fellows of the Academy are knowledgeable and experienced in family law matters. They've had numerous years of practice in family law, positive recommendations by other attorneys and judges, and have passed a rigorous written exam involving state and federal laws relating to the practice. At the end of this video is a list of publications authored by the Academy which are available through our website and may be of further assistance to you. We hope you find this video helpful. It is my pleasure to introduce Ms. Tamara Barney, our narrator.
Thank you, Marlene.
Thank you.
Finding the right family lawyer is perhaps the most daunting but most important part of the family law process. You will likely receive unsolicited advice from all sources, such as family and friends, but the most important person in the process is your family law attorney. All too often, when people try to do it themselves, they find out much later they did it wrong. Today, the law, in many instances, is very complex. There are several steps you should take before you see an attorney. Some things you should include making a list of your assets, liabilities, and income. You should also have a basic understanding of your monthly expenses. By doing preliminary work yourself, you will cut down the time your lawyer will have to spend gathering the information. Additionally, you should bring all papers that you think will be relevant to your case with you to your first meeting with the attorney. Always remember that it's very important to tell your lawyer all the facts, good and bad. He or she must know everything about your matter if a determination is to be made about your case, but know that your lawyer must keep them in the strictest confidence. However, many states do require that an attorney report any suspected child or elder abuse, neglect, or threat of immediate harm to another person, even though the information is obtained from their own client. In the last decade, several methods of alternative dispute resolution, or ADR, have become popular. These include collaborative law, mediation, and arbitration. The attorney who includes these options in their practice are specially trained. You should ask your attorney to explain these options and describe the benefits and risks of each of them, in addition to the benefits and risks of using the traditional litigation process. For many clients, a significant concern with searching for a matrimonial attorney is the cost. A straight, hourly rate fee arrangement is the most common type of fee structure. In this situation, your lawyer will require you to pay part of the fee in advance or upfront. This is called a retainer. This retainer is a deposit or a down payment to make sure that the client is prepared to pay for the lawyer's time. The amount of the retainer payment will vary from case to case and from lawyer to lawyer. Of course, your individual financial situation and the experience, reputation, and ability of the lawyers performing the service usually determines the amount of the retainer that the lawyer will request. For example, if you have substantial wealth and you are in a child custody battle with your spouse, chances are your lawyer will want a larger retainer than if you have a situation in which the financial issues are simple. There are no issues concerning children, and you only need a lawyer to prepare the documents and process the divorce. The latter situation is generally referred to as an uncontested divorce. Lawyers' average billable hours usually range from $150 to $1,000 per hour, depending on the lawyer and the jurisdiction in which he or she practices. Of course, every case is different, and the fees and hourly rates differ according to the lawyer's expertise, area, and locale. Divorces can typically cost anywhere from approximately $1,000 plus court fees and disbursements for uncontested divorces to tens and sometimes hundreds of thousands of dollars. They can even cost millions of dollars in very complex matters. As Abraham Lincoln said, a lawyer's time and advice is his stock in trade. A lawyer sells his or her expertise and training. Before being allowed to practice law, a lawyer must have satisfied certain criteria ranging from having successfully completed 3 years of law school to having passed the state bar examination. These requirements have been established to protect the public from being represented by unqualified individuals. Unlike a shop owner, an attorney sells knowledge to his or her client regarding how to accomplish a specific goal. In many states, a lawyer must provide you with a written letter of engagement and/or a written retainer agreement and a statement of client's rights and responsibilities. A retainer agreement is a contract setting forth the services to be performed and the fees to be paid. Both the attorney and the client sign the retainer agreement, and you should read this retainer agreement, drafted by your attorney, carefully before you sign it. This retainer agreement between you and your lawyer is a contract which, among other things, sets forth how the fee will be determined. It is important to remember that although you can ask the court to order your spouse to make a contribution towards your attorney fees, such awards are not mandatory or automatic. You should ask your attorney some background questions to get an idea of whether he or she possesses the knowledge and experience you need for your particular case. If your lawyer is a member of the American Academy of Matrimonial Lawyers, he or she is considered a leading practitioner in the field of family law. For example, you may want to ask, how long have you been practicing law? How long have you been practicing family law? Is your practice exclusively family law? How do you get along with other lawyers? How to use associates, paralegals, or a client to keep costs down and enhance your work on cases? Do you have any certifications or specialized training? What client handouts do you have that will be of assistance? How can you help me with my case? Also, ask for an estimate of total charges and a list of services covered in the estimate. Inquire about what steps your attorney expects to take and how much time and money they involve. An experienced lawyer should be able to outline the process for you with a fair degree of accuracy. Although many cases are resolved as standard or uncontested cases with no alimony, property, or child-related issues, many others are completely unpredictable. In fact, be wary of any attorney who promises to handle your case for a fixed sum, since it is impossible to tell what can occur in all but the most routine, uncontested divorce cases. The bottom line is that you should feel very comfortable working with whichever attorney you choose to engage. You and your spouse will each have the right to independent legal counsel in a divorce situation, regardless of whether you and your spouse agree to keep the divorce friendly. While you and your spouse may enter into the divorce process expecting to resolve things amicably, there is always a real possibility of problems occurring during the process or in the future. Each party should have his or her own attorney who represents only that party. It can become a serious problem when one lawyer represents both sides. One person cannot serve two masters effectively, and the courts have condemned the practice of having one attorney draw up a separation agreement for both parties. Although the courts will generally not set aside that agreement if it appears fair to both parties and there is no evidence of fraud or overreaching, this practice should be avoided. Courts have concluded that it is improper to represent both sides in a matrimonial action, even with consent and full disclosure.